interrupted Justice Barrett, and I want to make sure you get back to her.
Justice Kavanaugh, you can finish.
Go ahead.
I was just going to give you a variation of Justice Kagan's hypothetical. I have never heard of the drug that she was. Is that real? Okay. Let's imagine that it's marijuana. Okay, so let's say that you win this case and Congress comes back and says, you know, it conducts hearings, it hears all this evidence about the concentrations of THC in marijuana that's made today, documents that marijuana users who use it several times a week have a proclivity for violence with firearms, and then passes the same statute with findings along the lines I just sketched out. Can Congress do that consistently with the Second Amendment?
So I think you'd have to look at that evidence itself and decide, does it suffice to show that someone fits this pattern? If they could show that.
I have to look at the evidence to see if the person satisfies
No,
the
the
pattern?
category. If Congress wants to say we're going to do it at a categorical level, then I think you look and say, did they get the category right?
Okay,
I think
how do I make that judgment?
By thinking about the test that was applied historically. Has the government demonstrated that anybody who uses at the degree of this, that substance in that amount, in that frequency, is actually a danger, not even just when they're using, but in their day-to-day life? Are they unable to care for themselves and their affairs? That's
Do
the
I have
language.
experts?
I mean, if the government wants to do it on a categorical basis, it is going to have to prove up its case. If they don't want to do it that way, then applying the same test on an individualized basis should get you to the same result if they define the category correctly.
So the judge would then conduct an evidentiary hearing from experts on both sides about whether marijuana actually poses a risk of gun violence.
I mean, if the government wants to say, we want to set a categorical rule, I don't think it's too much to ask to hold them to
like,
put
could it do that for meth?
I don't, and as to some substances, I think it's not going to be that hard. It's just marijuana, we're all here and these cases arise because marijuana, boy, it would be difficult for the government to make that showing when it is the considered judgment of 40 states, the District of Columbia, 3 territories, and the president.
But you
that it's not that kind of substance.
But you can see that there are some substances that the government would have a pretty easy time on a categorical basis, maybe cocaine, maybe meth.
Absolutely. We are not here to suggest that you couldn't ever have a categorical approach as to a particular substance. It's just that if the government wants to do that, I think it has to do it under Bruin.
So it could have a categorical approach with respect to Justice Kagan's drug.
They can come make their case, and then you decide, I think the right test to apply is, did they define the category close enough to the habitual drunkard concept? Maybe, maybe the level of generality is enough to capture your drug. But it's not going to be enough to capture something that is the type of thing that people regularly all throughout the country lawfully use a few days a week, and most states and the president have made the judgment that that is not so categorically dangerous that nobody can use it safely.